Hello everyone, welcome back to my channel. I'm Michael Carbone. I'm a business and immigration attorney in Staten Island, New York. And today I want to talk about how getting a divorce can affect your pending green card application. Now, before I dive into this topic, if you have any questions, you want to start a conversation, please drop a comment below. Otherwise, if you'd like to set up a legal consultation, visit us at carboneattorneys.com. We have a button in the top right corner of our website. Click it, fill it out, and we'll get back to you as soon as possible. So when it comes to the green card application process, I'm gonna focus on family-based petitions, but ultimately, let's say you are married to a US citizen. Now, the crux of your green card application is that marriage itself, the authenticity of that marriage. Is it valid? Is it real? Or did you enter into this relationship in order for the non-citizen to get papers? Now, obviously, getting a divorce will have a major impact on your pending green card application. However, it really depends on whether or not your spouse, the US citizen or legal permanent resident, is cooperative or not with the application process. Now, for the purposes of this video, we're talking about separations, possibly filing divorce. Maybe the divorce is already filed. I'm not talking about divorced individuals. If you have a final judgment of divorce while your green card application is pending, the case is over. There is no longer a marital relationship between the parties, and USCIS will immediately deny the case. For everyone else, if you do have a pending divorce, you're thinking about divorce, you're separated from your partner, that is the focus of this video. Now, when it comes to this situation, if you do have a cooperative spouse, meaning they're willing to follow through and assist you in obtaining the green card, you still stand a chance with USCIS. The most important factor here is that you notify USCIS about the breakdown of the marriage. Now, if the marriage is valid at its inception and you can prove that you were in love, you got married, it just didn't work out, then you stand a stronger chance of success. If you can still prove that the marriage was valid and your spouse is willing to cooperate, you can still stand a chance of being successful when it comes to the interview. Now, the flip side of this is if your spouse is unwilling to assist. You are not on speaking terms, you have moved out of the house, or your spouse has moved out of the house, and they want nothing to do with assisting you in the green card application process. Unfortunately, if your spouse is unwilling to cooperate with your case, it is most likely a dead end. Their participation in this process is very crucial to the success of your application. If they're unwilling to testify and be interviewed and state to the legitimacy of your marriage, then it's very unlikely that USCIS will approve the application. Even if you can prove the validity of the marriage, there's a very good chance that the officer will still deny the case. Now, if you're at the point where your interview is, in a week or two or something like that, you may still want to take a shot and explain the situation to the officer instead of just avoiding the interview altogether. However, most likely, again, because your spouse is uncooperative, it's very likely that the case will be denied. So ultimately, a divorce can have a huge impact on your pending green card application. Obviously, if you are already divorced by the time the interview comes, that's an immediate denial. Your case will be denied no matter what. Now, if you are separated, you're contemplating divorce, or the divorce is pending, you do stand a better chance. And obviously, that scenario with a cooperative versus non-cooperative spouse will make or break your case. If you like this video and you want to see more, please like, subscribe, and I'll keep making them.